Good morning, everyone. I'm delighted to welcome you all to this morning's event, discussing the opportunities that Magnitsky-style sanctions present in the global fight against corruption. My name is Lucy Claridge, and I'm the Executive Director of the International Lawyers Project, ILP. For those of you that don't already know ILP, we're a UK-based NGO working to advance economic justice and the rule of law through the provision of pro bono legal expertise to civil society, communities, and governments throughout the world. We provide expert legal analysis, research, capacity building, policy and legal reform advice across 4 focus areas: anti-corruption, environment and sustainable development, tax and fiscal reform, and access to information and defending civic space. So as you may have realized, today we'll be focusing on the first thematic area of our work, anti-corruption. And I'm really excited about today's discussion and the launch of ILP's report for several reasons. Firstly, this is our first ever research report, hopefully the first of many, and it reaches some fascinating findings and recommendations, which you'll hear about shortly. Secondly, the research is emblematic of ILP's unique way of working, being the culmination of a highly collaborative project between ILP staff, legal fellows, partners, academics, volunteer lawyers, and with the very grateful support of OSF. We have some deep expertise on our panel here today, so I will hand over to Elizabeth Head, our moderator, to take that forward. Elizabeth, or Liz, as we will call her, is of counsel at Herbert Smith Freehills. She advises clients in relation to fraud, corruption, and money laundering. She has a particular specialism in relation to UK and EU sanctions, particularly those affecting Russia, Iran, Syria, and Libya, and has significant experience advising on internal and external investigations, including those conducted or instigated by the Serious Fraud Office, the Financial Conduct Authority, and Her Majesty's Revenue and Customs. Liz, we're clearly in excellent hands, so over to you. Thank you.
Thank you very much. And thank you everyone for joining us today. We're speaking on behalf of HSF. We're delighted to have been able to host, so thank you for giving us that opportunity. I'm going to ask some questions of our panel. We'll hear more about the research, and then we will have time for Q&A at the end. So please do think of any questions for our experts as we're going along. For those who are joining virtually, you can feel free to submit questions as we're going along, and we'll pick those up at the end when we turn to questions from the room. I will give you a very brief introduction to our panelists now, and then we'll introduce a bit more about their background as we turn to each of them for questions. But to start with, we have Anton Moiseienko on the screen, joining us from Australia. He is a lecturer in law and author at the Australian National University. Then in the room, next we have Tika Tsertsabadze, a senior policy analyst for Europe and East Asia with Open Society Foundations. And then next to Tika is Oliver Windridge, Senior Director for Governance and Anti-Corruption at the ILP. Just to introduce the topic a little bit before we turn to the panel, over recent years, several states have introduced legislation enabling them to impose targeted sanctions upon individuals involved in human rights violations and corruption, so-called Magnitsky sanctions. Currently, the number stands at 35 countries, with several others working on such provisions at the moment. And the Magnitsky laws have become an effective means of justice and accountability, especially where no other avenues are available or are severely limited. The International Lawyers Project, in partnership with Anton, undertook an empirical study of the aftermath of the first 20 corruption-related sanctions designations under the US Global Magnitsky Act. And the findings and recommendations are what is going to be presented today. Our expert panel are also then going to discuss various elements of the Magnitsky-style sanctions that are in force in the UK, the EU, and more broadly look at opportunities to strengthen global anti-corruption efforts. So we are in for an interesting session this morning. If I can turn to Anton first, to give you a bit more of an introduction to Anton, he is a lecturer in law at the Australian National University. and his work focuses on transnational crime, economic crime, and cybercrime, as well as the legal and policy aspects of targeted sanctions. Anton is the author of Corruption and Targeted Sanctions, a monograph on the legal and policy implications of Magnitsky laws, and has also co-edited 4 books on transnational crime. So Anton, thank you very much for joining us. And could you kick us off with an overview of the research, your findings, and the recommendations, please?
Thank you, Liz. Good morning, everyone. And first of all, let me check that we've overcome my technical difficulties and you can hear me okay?
Yep.
Wonderful. So now let's try to overcome the second hurdle, and I'll try to share some slides. I hope that will work as well. But as I'm trying to share the slides, just start telling you a bit about the background to the project. And the idea is very straightforward, but it is one that we hoped would be a useful endeavor to pursue. And the idea is to look, as you said, Liz, at the aftermath of the first 20 corruption designations under the US Global Magnitsky program. Why is that something that we thought is worth doing? There's been quite a lot of discussion, as many people following this webinar or the discussion in the room will know, about the effectiveness of sanctions. Different countries have adopted sanctions legislation that enables them to impose corruption and human rights related sanctions, starting with the US, then the UK, Canada, Australia. Now we're seeing movement from the European Union in terms of enacting a self-standing anti-corruption sanctions regime, but the abiding question remains of whether those measures are effective. And to date, quite a lot of the discussion has been dominated by the conversation about what sanctions should seek to achieve. What's the point? Are we looking to effect behavior change? Are sanctions a means of disruption? Something else? And that's a very valuable discussion. But as the International Lawyers Project and I were talking about the current state of the debate, we thought that another angle to it, which would be useful to add to the mix, and one that hasn't perhaps been addressed in quite some detail so far, is the actual impact of sanctions to date. So what's happened to the people who have been targeted? What were the actual consequences for them? And the thinking behind asking that question is that understanding the impact helps us better get a grasp of the realm of the possible, of what sanctions can achieve. Now, moving on to the methodology, we thought that time is ripe now to study the aftermath of sanctions for the first people who were designated under the Global Magnitsky program. And that's because, as the title of the report says, it's now been more than 5 years since the first batch of designations and the following batches have come through. And so it's reasonable to look back and say that some of the consequences are likely to have crystallized, and we can get a better sense of how sanctions play out in the midterm, at least. In principle, there's no reason why we couldn't do this analysis with human rights sanctions, but given our shared research interests, we decided to zoom in on corruption-related designations. And here on the slide, which should be reflected on the screen, but I'm not sure that you can see it, because I'm trying to move the slides, but it seems you're stuck on the first one.
We can see the list of individuals. That's
oh, you can. Fantastic. Okay, yeah, I just can't fully follow the way that it reflects in the room. Fantastic. So you see the list of individuals, and those of you who can count very fast would say, hang on a moment, there are only 18 individuals on that list, not 20. That's because 3 of those are grouped into a single family group, and these are people who form the Gupta family, a prominent one in India and South Africa, who were designated by the US in October 2019. So 20 people, 18 case studies, and we looked at what happened to those individuals after they were designated by the US. And the objective was, in addition to trying to understand the correlations, the impact, different factors that seem to be associated with greater or lesser impact and various forms of impact, we wanted to really provide a blueprint for this sort of analysis, so that other people who are interested in this work later on can use the same approach and conduct this analysis of individual designations and the impact that they produce. How did we go about carrying out the study on a more practical level? What did that involve? The bulk of analysis was comprised of a desk-based study. So we looked up publicly available sources to try and get a sense of what happened to the individuals on the receiving end of sanctions. We complemented that by 27 research interviews, and those research interviews had two purposes. First, we tried to fill the gaps in relation to specific individuals if we felt that we could expand on the information available in the public domain. And an example of that would be talking to journalists who cover specific regions, countries, or industries, and who have been following the fortunes of the individuals under sanctions. And the second objective was a more general one, and that was to understand the typical impact of designations, for example, the way that private sector actors interact with those who have been subjected to US sanctions. So we couldn't ask a bank, how do you deal with individual acts? But we could ask the bank, how in general do you approach compliance with global Magnitsky designations? What are the things that keep you awake at night? So this is the rough focus of the 27 research interviews that complemented the desk-based research. Before I move on to talking about the specific trends and findings that we have identified, I wanted to make a general observation that we felt is valuable in the context of this research, and that is to really summarize the various forms of impact that seem to be occurring. And it is important because we often are tempted to think about sanctions, or at least I was tempted to think about sanctions in terms of the obvious forms of impact. For example, have someone's assets been frozen? But as we undertook this research, it became clear that there are other, less obvious forms of impact that nonetheless can be significant and meaningful. And they might not always be ideally measurable, but they're important to bear in mind. And on this slide, you see 10 forms of impact that we thought can be gleaned from our analysis. And those are divided into 4 categories. First, you have the direct impact, asset freezes and travel bans. This is what sanctions say on the tin. If you are designated by the US under the global Magnitsky program, or indeed any other sanctions program, your assets will be frozen and you will not be able to travel to the country. In the context of this research, when we tried to look at asset freezes, what we were really interested in is the evidence of any assets actually being frozen, not just theoretically, not just an announcement being put out that says the assets of individuals A, B, and C are frozen, but some evidence that there has been an actual freezing of the assets that they possessed. And when we looked at travel bans, likewise, we tried to identify any indicia, any indications at all that those people had in fact planned to travel to the US, had some meaningful connections to the US, but were not able to do so after the sanctions were imposed. So we looked for some real impact in that sense. The second category is private sector action, and that's banks ceasing to do business with the target. And here we mean specifically non-US banks. For US banks, there is a legal obligation not to do business with an individual subject to US sanctions. But other banks around the world, even though technically not bound by US sanctions, may nonetheless choose to follow US sanctions designations for various reasons. So that was one of the private sector responses to sanctions designations in the US that we thought was a worthwhile one in terms of its impact. Other companies ceasing business, so similar to that. And then finally, media scrutiny, also an important form of impact for someone who ends up on a sanctions list. The third category was developments in the home jurisdiction of the person concerned. And this is a really interesting one because often sanctions are motivated by the need to address impunity and step in situations where the person concerned is shielded from law enforcement attention at home. But there are cases where home developments do occur, one category is criminal investigations or prosecutions. That requires no further explanation. Job loss or loss of political influence. And then finally, the fourth distinct category of impact that we thought is worth highlighting is behavior change, which, as I mentioned, is often thought of as the holy grail of sanctions. And we thought it's worth distinguishing between behavior change by the target and behavior change by the broader regime or network. So people taking notice of US sanctions designations and altering their behavior, perhaps changing the way that they run the country, they do politics or business. That arguably would be even better. And I'm going to say a couple of words later on about whether we saw any such impact. So let me now move on to the actual forms of impact that we have identified. And another sort of boring, pernickety, but important point that I should make here is that, of course, often it's not possible to measure those forms of impact with scientific certainty. We tried to reflect honestly our degree of confidence by adding qualifiers such as certain, possible, or likely, which you see in this table. It's still possible that other people would look at the information that we cite in the report and say that they would assess the forms of impact differently. It's also possible that it's inevitable that we hadn't had access to perfect, fulsome, and complete data. But nonetheless, it's still, I think, a useful exercise to look, even with all those imperfections, at the forms of impact that we were able to observe. So in half of all the case studies, we saw asset freezes actually having some significant real-life impact. We saw evidence of assets actually being frozen. In 2 case studies, we saw evidence of travel bans actually being meaningful and altering the operations or the lifestyle of the people concerned. From some of the other forms of impacts that were curious and are perhaps worth remarking on at this stage in this discussion is criminal investigation and prosecution under the section that deals with home developments. So if you look at the third category of impact, criminal investigations and prosecutions occurred in 3 case studies from the ones that we have looked at, which is interesting. And I'll say a couple more words about that later. We've also seen a couple of instances of the loss of political influence. Conversely, going back to that idea of the holy grail of behavior change, we've only seen that once by the target, and we haven't managed to glean any evidence of that happening in terms of the actions of the broader regime or network. One thing that is missing from this table is media scrutiny, and that's because we decided that it would be foolhardy to assess that, because in a sense, media scrutiny is a given. Arguably, that is something that is inevitably following from any sanctions designation, and the fact that we're able to do this research based on public source information is testament to the fact that media scrutiny has been significant in relation to all the individuals that we looked at. So that is the only form of impact that was left beyond the scope of this analysis. Here you see a visual representation of the same information that I've just taken you through. And what I think it brings into stark relief is the frequency with which we have seen asset freezes compared to other forms of impact. Of course, we were interested not only in documenting and cataloging those different ways in which sanctions manifest themselves impact-wise, but we also tried to understand, in part through the interviews that I mentioned, the determinative factors that affect the likelihood of any of those forms of impact coming to fruition. And the 3 issues that we focused on were asset freezes. So what determines the efficacy of asset freezes? What leads to that announcement of the assets of individual A are frozen to the actual immobilization, the actual freezing of their property? Then we looked at banks ceasing business with the target. And finally, we looked at instances where no impact at all were identified. And that's a third of case studies. In 6 out of 18 case studies, we've seen no impact at all. Being mindful of the time, I'll try to be brief in summarizing those determinative factors, and I would direct you to the report for more information. But the headlines are these. In relation to asset freezes, some designations contain information on associated individuals or companies. And in some instances, the designation itself might not contain that information, but follow-up designations occur, and associated individuals and companies are designated as well. In that way, the US government puts out into the public domain information on the network of the person concerned and facilitates compliance efforts by banks, which results in the actual asset freezes, or at least facilitates that greatly. Compare that to the situation where no such information is available, and what you receive as a bank is simply a list of people subjected to sanctions. Then, in effect, what happens is that you as a bank rely on third-party service providers who will give you additional information about the people concerned, who might conduct their own analysis and might package that analytics into summaries of potentially affiliated companies, individuals, but that is wholly reliant on the information that you get from your third-party service provider. In many instances, that information will not be available at all. And so banks, in a sense, are left on their own, and the freezing of assets becomes much more complicated and less likely if no additional information is provided by the government itself. So the availability of that greater array of data on associated individuals and companies and the corporate networks writ large seems to be essential to the effect or impact of asset freezes. Non-US banks ceasing to do business with individuals concerned is something that is a frequent occurrence just by virtue of the centrality of the US financial system and their unwillingness to get into any trouble with US regulators. That is a fact of life, and probably not really a groundbreaking finding, but one that is nonetheless important in our view to bear in mind. And then the really interesting issue is, when do sanctions have no impact at all? When do they fall flat? Here we identified 2 factors that seem to be particularly disproportionately important. One of those is governmental opposition towards sanctions in the home country of the individual. And there can be different sources for that opposition. Sometimes it's geopolitical tensions, but sometimes it's simply the influence of that individual in the country concerned. It's not always the case of countries that, for example, have geopolitical tensions with the US. Sometimes it's simply a reflection of local politics. And then another factor that once again comes into play here is that availability, or rather lack of availability, of information on the broader corporate network, associated individuals or companies. And here is what we've seen in terms of the proportion of designations where an associated individual or company has been designated as well, in terms of the case studies that we looked at. In fact, in the majority of the case studies from the earliest batches of designations, 56% of those, there has been an associated individual or company that was designated as well. And it would be interesting to see how that compares to later designations under the Global Magnitsky program. It might, for example, be the case that the earliest designations have greater information associated with them, have greater availability of information by virtue, for example, of the high-profile nature of a lot of those sanctions. Here is another infographic that I think is of some interest, and that is the proportion of cases involving prior domestic action of some description, and investigation or conviction happened at home in half. There's something slightly wrong with the numbers on this slide, but half of the cases that we looked at, which is an interesting finding because it really raises questions about the objectives and purposes of global Magnitsky designations. If someone has been processed by their home country in terms of action having been taken against them already, what is the added benefit of a US sanctions designation? And this is exactly what we have seen in our sample, because investigations and convictions that I'm talking about here happened before US sanctions, not after US sanctions. There are possible answers that can be given to that. And one of those is to say that US sanctions validates the actions of the domestic justice system. So, for example, you've been investigated and prosecuted in Uzbekistan, and then that is followed by a US sanctions designation. And that is, in a sense, an indication of US approval of that overseas investigation or prosecution. But it is an interesting situation that I think is really worth thinking about. What is the interplay between domestic action and US sanctions, and what is the added value of US sanctions in that context? Another important issue that other NGOs have usefully highlighted before, and especially I should give a shout out to the report that was published last year by Human Rights First, Redress, OSF, and the Roel Wallenberg Foundation, is the multilateral nature of some designations and very often the absence of multilateral action. Interestingly, in our sample, there were a number of cases where US sanctions were followed later by UK sanctions. We haven't seen any sanctions by other countries in our sample, but in fact, in a majority of cases that we covered, in 56% of those, there were later UK designations that took place. And once again, that is quite interesting because we're not sure whether that is representative of the broader sanctions pattern or whether that is something that is unique to the case studies that we looked at, because they are typically associated with high-profile individuals. And of course, these were the first sanctions imposed by the US under the Global Magnitsky Act, and therefore, presumably, that itself attracted quite a lot of attention around the world. And then finally, moving towards the end of my presentation, those cases of no impact that I've mentioned. Here you see the range of different countries from which those people hail. And you've got Russia, so no surprise there. There are geopolitical reasons why Russia would not take action against someone sanctioned by the US. But then we've got a whole range of other countries as well: Nicaragua, Iraq, South Sudan. Well, in fact, those three countries in addition to Russia. And not all of them were at the time experiencing any tensions with the US, but in some cases, it appears that individuals concerned were powerful in their home jurisdictions. And in fact, in Iraq, there was high-level official opposition that was expressed against the US sanctions against some of the individuals concerned. So there is a bit of a mixture of reasons there why sanctions have no impact, but all of them seem to boil down to some level of opposition in the country concerned. So what then are the recommendations that we can make based on that analysis? There are four main recommendations that we offer. The first one is a conceptual one. Governments should not assess the effectiveness of sanctions purely in terms of measurable outcomes, such as the amount of assets frozen. We are all drawn towards something that is tangible and measurable. But in fact, as we've seen, there are many other categories of impact that might be difficult to ascertain. They might not be amenable to scientific measurement, but that's not to say that they're not important. And that's not to say that sanctions that achieve those forms of impact are by definition ineffectual. They can be meaningful, they can matter. One just needs to think about them in a different way than, for example, when one thinks about the amount of assets frozen. Secondly, governments should seek to identify and publicize corporate networks associated with targeted individuals for the reasons that I mentioned. Third, in determining appropriate targets for global Magnitsky sanctions, governments should prioritize individuals who rely on the international financial system and therefore are more likely to be affected by the designation. And fourth, in imposing global Magnitsky sanctions on those whose wrongdoing has been addressed by domestic justice systems, governments should develop a clear understanding of the added value that the designation would have in the circumstances. And the very final comment that I would make is that in addition to that analysis and recommendations, as I said, we see one of the benefits of this research in providing a blueprint for this kind of analysis that can enable others, should they wish to do so, look at more people who've been designated under different programs, people who were designated after the individuals that we looked at. And we hope that the more of that analysis happens, the better collective understanding we can develop of the impact of sanctions, of different factors that are associated with that impact. And that in turn can drive forward the ever important discussion on effectiveness. So I'll stop here and thank you very much for your patience.
Thank you, Anton. That was fascinating. Thank you very much for taking us through the very, very detailed research. What I will do next is invite each of our panelists to give us a few minutes on their kind of initial responses to the findings and their recommendations before we delve into some more detail. I'll turn to Tika next. So Tika is a senior policy analyst on EU foreign policy at the Open Society Foundation's Europe and Central Programme. Tika is responsible for EU sanctions policies analyses and advocacy. She also has thematic expertise in the EU's human rights policies, in external action and civil society. So prior to joining Open Society, she worked for the International Partnership for Human Rights, focusing on Eastern Europe, Russia, and Central Asia, as an advocacy director and gender advisor for 5 years. She worked at FRIDE, a European think tank based in Brussels and Madrid between 2010 and 2014 as Central Asia Programme Manager, and conducted research and advocacy on EU policies towards Central Asia and the South Caucasus. She co-managed a 50-member network of Brussels-based HRDN networks between 2016 and 2019. So plenty of relevant experience to bring to bear, Tika. What are your initial thoughts on the research?
Thank you very much, and very happy to be here today and representing also Open Society Foundations here. And we are very happy to be partnering with International Lawyers Project in this very, very important and timely research. I'm representing EU jurisdiction in a way. This is my specialty. So when we started this research together with International Lawyers Project, one of the ideas we had is also to use it for our advocacy and policy work towards EU officials, EU institutions, to demonstrate that this is not a linear world and there is quite a lot to unpack and to learn from. I think this research comes at a very, very opportune time where the dominant narrative out there in media, if you search sanctions, the pictures that come out are the of hunger, of disruption, of humanitarian impact, and those of us who are advocating for targeted or specific, very specific sanctions, we are a little bit struggling with narrative change. So it is very important to have this type of research now to unpack the complexity of it. And this is not one story only. A traditional way of looking at sanctions impact has been through a coercion to behavioral change, which is a very important aspect in the policy objective setting. However, to me, it looks like a bit of a narrow sense, the very narrow definition of the impact of the sanctions. And all of us, whether we are in civil society, academia, think tank, or in government, we should really move towards more how to make sanctions work better rather than sanctions have impact or not. So the study now uncovers a number of issues. If you look at the case studies, there are fascinating data in there, but I picked up 3 major takeaways from me. First is a complexity of the issue, and we shouldn't prejudge or assess superficially the impact sanctions might have or might not have. And this is because the study shows you need a cooperation and coordination from multiplicity of actors, primarily the financial institutions, which is extremely difficult for privacy reasons or whatnot. Governments have a very cumbersome task to assess the impact of the sanctions. This is not unbiased procedure. It requires a lot of heavy lifting, and sometimes it can be subjective. But very importantly, I think the view of the civil society locally is very important. And the way we see the impact from the major centers, whether Brussels, London, or Washington, D.C., it can be very different, the view from the local perspective. So having this dialogue with local actors who are at the forefront of documentation of many of these designations is very, very crucial. My second takeaway will be the recommendations that Anton gives in the report to target those who rely on international financial system. And this is very important because it can have a, like what Emily just mentioned, disruptive effect, right? By preventing them to access the international or Western financial system, to disable their networks. And it's no surprise, and there's a lot of evidence of this out there already, that corrupt actors or malign actors opt for jurisdictions which have independent judiciary, rule of law to protect their rights and interests. And the problem here is it's not only to prevent them to access the Western financial system, but to protect the democracies and to protect the democratic institutions, because this type of corruption does have a corrosive impact on our society, on our institutions. It undermines the trust of the society and citizens in the institutions. It is a national security risk, corruption. It's been identified as such by the US government and by the UK government. So it's much more than just sanctioning somebody and freezing their assets. It does affect the institutions internally. And I think this is something to be aware and to be very wary. And my third takeaway would be the recommendation where Anton refers to targeting or publishing corporate networks. And this is very important, and I would go even further to say that even before designations, we need to understand the political economy in a given context. In many local, national, or regional level, political economies don't function the way the West understands. These are family relationships, business associates. Very often you don't find the beneficial owners on the same name that own these assets. It's a very common practice. So understanding this political economy is important. And here local actors actually can be a very, very crucial players to make us understand how specific economies function, because these are informal economies very often. And this is especially very important because currently in the context of the Russia sanctions and the discussion about sanctions evasion, circumvention, and the role of professional enablers has somehow become very, very relevant. And it is very important in that context also how these local economies function and how professional enablers help disguise these corporate networks. I will leave at that and happy to answer any questions. Thanks so much.
Thank you very much, Tika. And then last but not least, turning to Oliver. Oliver is the Senior Director for Governance and Anti-Corruption at ILP. He is a currently non-practicing qualified solicitor in England and Wales and spent over 7 years as a legal officer at the United Nations, working in the trial and appeals chambers in the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for the former Yugoslavia. Since leaving the UN, Oliver has served as independent counsel, consultant, and advisor to numerous civil society organizations, bar associations, regional bodies, and individuals. He has appeared in cases before several international and regional courts and bodies, including the International Criminal Court, the African Court on Human and People's Rights, the UN Human Rights Committee, and the UN Working Group on Arbitrary Detention. At ILP, Oliver is focused on how emerging tools in the anti-corruption and accountability space, such as sanctions, can best be utilized alongside more established forms of accountability. So Oliver, same question to you. What are your top takeaways from the research?
Thanks, Liz. And it's always a problem with going last on a panel is that everybody, particularly such an expert panel. But first of all, my congratulations to Anton, Megan, and Eva as well. It's wonderful to see this in the flesh, so to speak. I know it's been a lot of hard work and a lot of hours have been spent on it, so congratulations. Just a few points, and then I'm keen to go to the Q&A. But I think the first one is, I think Emily alluded to this, that this is really, in my experience, it does answer a call from governments, both the US government, the UK, EU, Canada, whoever, that when we are engaging with governments, the ask is often to understand the impact, to understand how sanctions are being, whether they're being effective and the impact. So I think this does go, it's not a complete answer, but it does go some way to answering some of those requests that government have made of civil society. So that's hopefully a good start. I think it's interesting that the timing, these designations all run from about 2017, we will have seen on the slide. So again, I think to Emily's point on the shifting sort of sands of sanctions and its use, we do sometimes, and I include civil society primarily in this, sometimes fall into the trap of thinking of sanctions as somewhat of a silver bullet, that this is the new way that we will be able to sort of come to a solution to everything, and it's not. But I am interested in this. We haven't taken, or Anton and his team haven't taken the most recent sanctions and tried to demonstrate impact, but we've gone from 2017. So in a way, I think this hopefully demonstrates to a certain extent the sort of more medium to long-term nature of sanctions. There is obviously the short-term direct, assets are frozen, travel bans, what have you. But this, I think, really does go to the nature of those who've been practicing in sanctions for many, many years, that these are often much more sort of medium, long-term impact. So hopefully this will help to sort of counter the narrative or push back on, or sort of, I don't know, level up the narrative that it's all about the immediate. And that's, it is a civil society thing. Dare I say, it's also a government thing as well. Particularly we've seen over the last year or so with the Russia sanctions, is sort of the immediacy of the impact. So I would just sort of highlight that and commend that aspect of it. In terms of the framework for future work, I think it's a really interesting effort to go beyond those sort of immediate frozen assets, travel bans. And something that we're very interested in is these sort of indirect impact and how you actually assess it. It's very, very difficult to sort of assess that indirect input. And Anton did a good job of sort of explaining how and why. But we do see through the work that we do when we work with civil society partners on the ground, these kinds of impacts. And I think one of them that's touched on the sort of assessment around sort of the provision of professional services, something like that, where, even if an individual doesn't have, say they have limited assets, let's take the US, because this is a US paper, they have limited assets, so they have assets in multiple jurisdictions. Let's face it, most corrupt designees, well, not all, but most, will have sort of assets spread around the world. They may well have property, they may be able to travel to other countries. We do find that whilst, I can go and spend my money in Geneva, I can go and live in my house in Singapore, it is a lot harder for individuals to move, and again, conscious of where I am, lawyers, accountants, advisors, and those kinds of businesses. So this kind of impact, this kind of indirect impact on particularly corrupt individuals' ability to not only access their funds, but access services, I think is a really interesting and important point. And I think it's one that we need to continue to examine in terms of why it is that when you block London or New York or Brussels, we not only freeze their assets, but we also prevent them. Well, I mean, you can have, obviously, licenses can be granted, but you essentially make it a lot more difficult for people to access the professional services that these kinds of cities are experts in. And I do think your point, Tika, on assessing impact through engaging with local NGOs, if I understood right, and other groups is a really important one. And when we do work with local civil society actors, some of that impact, it's not necessarily directly on the individual, but it, again, maybe to the point on the need to maybe go into the media issue, is all that kind of extra stuff that goes in around media reporting is really important. So hopefully that might be another strand to it. Two quick points, and then I'll finish. One is that, I think it's, I totally take Emily's point that, we have to act with caution when we say there was no impact. But I think it's not a bad well, I suppose it is a bad thing that there was limited, let's call it limited impact. But I don't think that's necessarily, a failure of a report or a failure of a sanctions regime. Again, it goes to this sort of silver bullet thinking, the expectation that every sanctions designation will lead to sort of massive impact. I'm not sure, for people online and in the room who work on other forms of accountability, if we hold other forms of accountability to the same standard, you will find other forms of accountability. Sometimes it works, sometimes it doesn't, but we don't sort of throw the entire project out because, somebody was acquitted at an international tribunal, for example, or something like that. So I think having cases where impact was limited, or it's really difficult to find, is as valuable, if not more valuable, than the cases where there was direct impact. So I think that's something to think about. And then finally, again, just to pick up on one of the points, I think it was Emily around, and I think both my panelists have, my co-panelists have made around the impact in country and the sort of, has that person hired high-profile, very expensive lawyers to lobby on their behalf in DC to try and get them off list, some of which individuals are in this report. As well as sort of changes to sort of in-country regulation, maybe legislation. That's really, really impactful, but I'm also aware that that's a heavy lift. So, you have to be an expert in a country to be able to say, we've really actually seen sort of a significant shift in the political tone towards, corruption or something like that. And so it just goes to the point, which maybe I'll make later when we do questions and answers, around the need to really see sanctions, as Emily said, a tool in the toolbox, pardon the cliche, and that we need to be working, whether it's US government, UK government, or whatever, across sort of skill sets and, outside of silos, because to my experience, the people who are best served to be able to tell you about those other forms of impact, the forms of impact around political change, around, piece of legislation that has been stuck in, Parliament for ages, and now all of a sudden it's gone through, are going to be country experts. So they're going to be desk officers, they may be law enforcement specialists who are working in country. And that requires them to be able to feed in and report back the impact as well. So I think when we're looking at impact, we need to sort of encourage or hopefully foster a sort of collective collegiate spirit. I'll leave it there. Thank you.
Thank you very much. Excuse me. We will perhaps come back to the specifics of the research in Q&A, but I wanted to just broaden this discussion out slightly more, and we can perhaps talk more generally about sanctions as an anti-corruption tool and what else is out there. And maybe to the EU now. Tico, in May, we had the EU's measures to fight corruption both inside and outside of the EU. Could you talk us through what stage the proposals are at currently? And then second question, would a separate regime be better in your view, as opposed to adding corruption to human rights or country regimes as appropriate?
Sure. EU is probably outlier in this discussion because the only jurisdiction among Australia, Canada, UK, and US that doesn't have this kind of framework, where, like what Emily was referring as one of the last points, cooperation with international partners, makes you really lag behind. I think Moldova example was very interesting in that context. When US did the designations in October, UK followed in December. We were very vocal that EU doesn't have adequate sanctions regime to support a country which was a candidate country already, and which, as rightly pointed out by Emily, actually government was very keen for these designations. It's a support to the government. But what we have seen, you come together very quickly to adopt a very specific Moldova regime and follow the designation. So there is a way around it, but having a one framework certainly would have made the job much easier. So now it's been a long way for the EU to come. We have heard the President of the European Commission, Ursula von der Leyen, announced it in September 2022, the first political commitment by the EU, in fact, to adopt such sanctions regime. It is part of the work program with the European Commission for 2023. And in May, High Representative tabled the proposal for a standalone sanctions regime together with a broader anti-corruption proposal, which I believe is a very good step, because you cannot tackle corruption outside of the EU if you don't put your house in order. And it's a good approach to tackle corruption inside EU. It's no surprise we have issues of corruption in a number of EU member states, if not in all. Where the proposal is now, the proposal is tabled to the Council, and it's effectively up to the member states of the European Union to come up with a political agreement and then work on the legal and technical aspects of it. So I am not in a position, I'm not sitting, unfortunately, in those meetings, so it's a little bit hard to navigate where things stand, but judging from the political weight you has put behind this proposal, we should expect that it's gonna come sooner rather than later. And I think the political momentum is particularly very important given geopolitics in Europe, given the revelations about the corruption inside and outside of the EU. And so if EU misses the political opportunity, it will be much harder for it to move. To your second question, our view is that you should ideally follow the UK's track to have standalone sanctions regime. This is what the proposal is about, which was tabled by High Representative. And the reason is that EU already has suffered, it has a huge vulnerability to cost challenges, right? Case law in the EU is developed over the last 12 years. And we have seen, in fact, quite unfortunate developments. Anti-corruption sanctions are not novelty in the EU, and EU has probably seen bitter examples on Ukraine, Egypt, and Tunisia sanctions, misappropriation of the state funds, where these regimes essentially have collapsed because of the reliance of the evidence from the partner governments. And I think that's one of the factors why there's a lot of reluctance, a lot of slow movement, how to not to repeat same mistakes. So for that reason, because of the vulnerabilities at the court level, the rights of the designees to be heard and to challenge, I believe it's better to separate. The human rights violations are open, it happens in front of our eyes, corruption is covered. So the kind of evidence we need is very different. And I think for that reason, it's better to have it, two separate regimes.
Thank you very much. One final question from me, and then we'll open it up to the floor. But coming back to one of the themes of the day of evasion, circumvention, and so on, Oliver, given that assets are currently not being caught, designees or potential designees are finding increasingly sophisticated ways to keep their assets out of reach. In the light of the ongoing desire to give sanctions proper teeth, to deal with dirty money, how can we make the best of the sanctions we do have? Especially, I think, if we're talking about freezing orders, how can frozen assets be repurposed, used? One of the big topics at the moment in Russia, of course, but also more broadly.
Yeah, I mean, it's very topical. Obviously, but both from a sort of, you know, dare I say it, sort of from a foreign policy point of view, but from a political point of view, I think we see enormous political will, not least probably as a result of some politicians who were, you know, last year posting, you know, pictures themselves in front of yachts saying this will be, you know, on its way to Ukraine soon, and it wasn't. So there is a political will, certainly. And I think it goes back to this issue of sort of, I would push back on the question a little bit, because really on the purpose of sanctions, they're not a silver bullet, like I said, and I think we tend to think, well, why aren't sanctions doing more? Whereas, you know, sanctions are limited in what they can do. And, you know, it's more about sharpening the teeth rather than sort of, you know, you can't put a lion's teeth in a domestic cat. So the question is really, how do we get better at it? But I guess to answer your first question, or one of your questions in terms of the sort of whole issue around sort of freeze to seize, I think the reality is that sanctions, and this is my personal view, is that sanctions are unlikely to form a clear bridge between freeze to seize, because frankly, if the government had managed to do it, it would have happened by now, particularly in relation to Russia. Because as people online and in the room will know as well, if not better than me, you know, we're talking about two different regimes, and we need a sort of a finding of sort of either unlawfulness or some sort of conduct that brings it into the sort of the seize aspect. So I think sanctions can play a part in the sort of issue around corruption, and particularly in a vacuum. If you compare it to human rights, for example, and there's nothing, this is not a sort of a dig on the human rights sanctions at all, but where you have other forms of accountability for human rights violations. I do struggle, other than sort of domestic criminal prosecutions, which we know it's so difficult, or maybe something under sort of the Bribery Act here in the UK, sort of cross-border nature. Sanctions are one of the only sort of anti-corruption tools that we sort of have in the toolbox. It's only one of some, but it is a much more sort of impactful one, I think, than sort of something like human rights, where we have various venues to go. So we need to get better at using sanctions. I do think the way we do, I think, there's multiple ways you do it. I will push back a little bit on Emily's, I do think, I mean, it's easy for me to say I'm on the outside, but I do think we need to expand the scope of the global anti-corruption sanctions regime. I get Emily's points that it gives a legitimacy around the UNCAC, the required sort of criminalization. But I do think we could maintain that legitimacy by expanding the conduct somewhat. So I think that's one way we could essentially try and capture more forms of corruption. I do think this approach around network sanctions is an important one. Which essentially, as I understand it, really means rather than going after a specific individual, you go after the network that surrounds them, and particularly for corruption sanctions, maybe not so much for other ones, but for, like we've said, like Tika and Emily have said, where you have enablers and teams of people that are helping these individuals to hide and move their assets. This network approach is a really important one, and I think this is one of the recommendations in the report as well. And I think we have seen success on that. If you look at the sanctions around Dan Gertler, which are in the report and are well known, this was not only about sanctioning one individual, but continually going back to second time, a third time, to add more companies, to add more enablers to it. I will say, knowing some of the people who work at OFAC that were working on it, that's an enormous lift. And so I don't say that lightly. I don't sort of say, oh, that's an easy thing you can do. It is hard work to put together a network approach to sanctions. And so I don't think that's an easy ask, but I think particularly for corruption, if we're looking at these networks, if we're looking at the ways of going after these individuals, I will say not the problem, one of the heaviest lifts around that is that you end up sanctioning individuals, that the enablers is one space removed from the corruption. So it then becomes more difficult. You then probably potentially expose yourself to further sort of litigation and some of these issues where individuals are sort of enabling rather than themselves sort of fully involved. But I think we need to look particularly at anti-corruption sanctions through that sort of network lens. I mean, I think what some of the work that the UK is doing right now, the recent announcement on the Russia stuff is really, really interesting. It's innovative. Kudos to Emily and all those who worked on that for thinking of new and innovative ways to sort of get at this. I think of those three sort of announcements that came out recently, the one around what I think it must be sort of state assets and the new purpose for sanctions to be in place for rebuilding Ukraine is really interesting. I think the voluntary donations one, let's see, who knows? I am very interested. I mean, as I understand it, and correct me if I'm wrong, Emily, but there will be sort of provision made, or it will be easier for those who are sanctioned to donate frozen assets for the purposes of rebuilding Ukraine or reconstruction Ukraine. I think basically is the idea. But then if you read that section, there's a whole thing about this doesn't mean that you'll be delisted. This doesn't mean that you'll get any kind of favorable, which is sort of like absolutely correct that that's in there. But it will be interesting to see A, if anybody takes that up, and B, what happens to it. But again, it's about closing loopholes and finding innovative ways to do it. But I think of those, just to finish on that point, of those three initiatives, I think the one that got the least attention, I think, is the most important one, which is this requirement to sort of declare assets, which I think, well, probably for the lawyers in the room is also like, there's some more work for you guys to do, right? So I'll just say that. And that will obviously be a heavier lift for the Foreign Office and OFSI in particular to sift through that. But again, I do think it's about understanding loopholes, understanding gaps within the regime, and then closing them. So again, like to finish on a positive, that is the kind of innovative thinking that I think we need. I'm not sure if all of those, some of them will be particularly, impactful. I guess the idea is they would, otherwise they wouldn't have been put in. But this sort of the ability to close gaps, the ability to sort of look at an evolving situation, which really is one of the advantages of sanctions, right? Is that you can take people off, it's companies, it's individuals, you can be very flexible when it's used really well, is the way that you really go after the sort of dirty money. But also, just to go back to my first point as well, is just within that sort of overarching sense of sanctions only being able to do so much, when combating dirty money and illicit finance. Thanks.
Thank you very much. Complexity is the name of the game, I think, with all of this. We're looking at individual parts of a hugely complex and detailed whole. Enough from me. I'm sure we have plenty of questions in the room and online. Yes.
Cool. Thanks. Should I say who I am and where I come from, or not?
If you're happy to.
Yeah, I'm James Bolton-Jones from Spotlight on Corruption. So I have two related questions. The first is, to what extent do the panelists think that it would be useful to kind of really build in this sort of analysis, post-fact analysis that this amazing research represents into every designation to kind of really understand how they're working, learn lessons, etc.
How much do you relish the concept of doing that for however many thousands of people we have on the list currently?
Yes, that's what I want to dedicate the rest of my life to. I mean, I think it is obviously, this research, the way I think I see it is, 20 people is not an awful lot. 20 people, 18 case studies. And so if a government or if civil society or academia had a more extensive database of, consequences of sanctions, I think that would be really useful, and that would provide the kind of rich trove of data that would actually be genuinely helpful in guiding the imposition of sanctions. So yes, I think there's definitely an argument in favor of doing more of that sort of analysis. Whether that should be the job of someone in a government sanctions office in addition to the rest of their responsibilities is probably not for me to say anything about.
Thank you. Tika or Oliver, do you have anything to add?
Just maybe one sentence to add. I do see the value of having, maybe not on hundreds of designations, but there is a lot of research about unintended consequences of sanctions because of the historical reasons of 90s, Yemen, Iraq. And that research really impacts the work of targeted sanctions. And if you ask ordinary people in the streets, they wouldn't distinguish between targeted and those kinds of sanctions. And I think we do need to shift the narrative. And to shift the narrative, we need the data, we need the research. And for that reason, I would say we need more research. And it's a responsibility of all of us. It's not only a responsibility of governments. I mean, we know EU also is doing annual reviews, but it's not this kind of methodological review or indicators-based review. So I think as a civil society and academia can play an important role there, being selective where to assess, but we would certainly need to build on that.
I mean, I think the only point on the licenses, I think I know where you're coming from, James, but I do think, for what it's worth, in the UK we have a balance. This information does come out in court cases. It does come out and I think there is a right, as unpopular as it may be among, there is a right to privacy and a right to protection of those individuals who want to engage with government and and seek licenses and what have you. I think we have, I mean, I would be biased, I'm from the UK, but we have a balance in this country that maybe there isn't in the US, for example, and that's just my comment around, the sort of appellate sort of procedure, but we have an appellate procedure in this country built into sort of SAMLA and challenging designations as well as licenses that I think does allow for us both individuals to challenge and the actual designations of trying to obtain licenses, but also allows for sort of free flow of public information. I mean, And on the second point, I'm sure Anton would love it if the UK government would apply his framework to every designation. But it did make me think, it's a really good question. And it did make me think that, I mean, this is sort of an open invitation to Emily and her team, but I think probably certainly on behalf of ILP, but maybe others, is we do quite often engage with the Foreign Office and OFAC and others pre-designation. And I know there's going to be challenges around talking too much about specific designations behind closed doors where people are, but I do wonder if there is a vehicle where civil society can, you know, just as we bring packets of information to sanctioning authorities for their consideration, whether or not we may be able to also sort of do a post-designation package. I mean, that's a lot of work for someone to talk through that, you know, just as we sort of talk through before a designation, these are the reasons why we think this would be, here's the other evidence. Maybe there is that space for us to say, well, here's a collection, you know, because we do often get that information from our civil society partners on the ground. We'd like to come in and talk about it. Like I say, as I'm saying, I'm really seeing the challenges around talking about particular individuals and what have you, but there may be that ability to have some sort of space to talk about impact, even if we somehow, I don't know, anonymize it a little bit to protect people. Just an idea. Good question. Thanks.
Hi, my name is Natalia and I work on human rights sanction at the NGO Redress. I also have two questions. My first one is in relation to the methodology. When you started doing the assessment, did you first define the categories of impact and then apply them to the case studies? Or did you also continue devising the categories of impact when you went through the different case studies? And my second question is in relation to the recommendations. I think the findings in relation to behavior change are a bit disappointing. And I was wondering if it could potentially be a recommendation to also say that greater guidance should be given what the target should do for the sanction to be lifted. Because I think at the moment, a lot of focus is on what's the impact of the sanctions, but not so much on what could be the potential impact of a promise to lift the sanctions.
Over to you, Anton.
Yes, so the first question, the answer is the latter. The development of the categories of impact was following the case studies, not the other way around. And then in relation to the identification of the criteria for people to be delisted, I have to say I haven't thought too much about it, and probably others on the panel have more well-formed views around that. But I think that in relation to corruption, the challenge there is that very often sanctions respond to serious corruption that has already occurred. And it's not always easy to identify any particular form of behavior that would, as it were, undo the consequences of that corruption. And so I think it can be quite difficult to give a very clear prescription as to how a person should behave in order to get off a sanctions list. And I'm not sure that it would be desirable in all cases. So it's a very unsatisfactory response to, I think, a great question, but that's probably where I stand at the moment. So I'm not really sure. I feel that probably in a lot of sanctions designations, it is not really essential to give that clear way out for the person concerned. You know, if they want to remedy their behavior and play a more constructive role, it is, as it were, up to them to, you know, figure out how they do it and then engage with the government that sanctioned them. It's probably not for that government to identify a very clear way out, but I'm sure that others might view that in a different way.
I think we've had an online question which is similar.
Very similar, yeah. So I'll read it out though. It says, I'm interested in efforts to undo sanctions designations. For example, president of DRC just last month lobbying the Biden administration on behalf of Dan Gertler to remove sanctions. What does the panel think about this and what should be done? For example, I cannot think of a single credible reason for this effort by the president of the DRC. Does he earn some kind of pariah status for doing so? This was from Mr. Simon Taylor.
I think it was covered quite well. I mean, I don't think the sanction should be removed on the basis of the lobbying from certain government officials. It should be based on the concrete evidence of behavior change. And I think we already covered quite well how difficult that aspect is to document behavioral change. What does it exactly means? Is, for example, on the European Union side, sometimes there's a huge criticism that regulations that come out doesn't even mention what is it that individuals should do to get off the list. However, there is a council conclusions that precede the regulations, and very often people don't read those conclusions, which actually outline very clearly why the sanctions are not something that's imposed as a first measure. There are many other things, and that's why we should read the documents in totality to really get to the bottom of it, why sanctions were imposed in the first place and what it would require to get out of it. And it should be evidence-based, it should be legally sound. I don't think we should go around with the question that if government officials lobby, I don't think we should take it serious, but it should be on a sound legal basis, and otherwise we undermine the sanctions if we just delist people because somebody has lobbied.
I mean, I think the only thing I would add is, I mean, delisting is a really important issue. I think for a lot of the designations we're talking about here, you know, the designations are very carefully crafted, and they are sort of announced with reasons. It's not really an answer to your question, but more of a sort of a comment myself would be, I think delisting becomes, I'll just say, delisting becomes more of an issue where you have sanctions regimes where the reasons for designation are wider and wider and wider, put it that way. In these particular cases where we're talking about sanctions on anti-corruption, you're talking about an individual for one of the, you know, bribery or misappropriation of property, and for this, and it's set out. So you have a very set conduct. My concern, and so you still need to obviously think about delisting for that, but I would argue that that would be easier. The concern I have is around sanctions regimes which are very widely drawn, Russia, how you're sort of creating this situation where it becomes a lot harder for people to even sort of understand, to a certain extent. Well, they probably understand why they're on the, because there is an announcement, but it becomes harder. So I think that we're talking about two slightly different things. And on Simon's point on lobbying, you know, again, to go back to my point of, you know, the UK in particular has a much more sort of formal, clear sort of system, as opposed to the US, which relies a lot more sort of the dark arts of lobbying behind the scenes, you know, with expensive lawyers or what have you. So I think there is sort of those sort of avenues to challenge are a clearer way of doing things that gets around this issue of lobbying, whoever the person is.
Yeah, there's another question here, and then I think we've got a few more online ones, so we'll come to those next.
Thanks very much. Natalie Lucas from Redress and the UK Anti-Corruption Coalition. Thank you for the really great report. It's been really interesting listening. I have a question for Anton, again, I guess on a little bit on methodology. Did you take into account the enforcement actions? I think so, you know, currently in the UK, there hasn't been too much enforcement of sanctions sort of from OFSI in terms of penalties and things like that. And I imagine the US is maybe a little bit more active in terms of enforcing their sanctions regimes. I'm not sure, but I'm assuming. And so when you were looking at sort of private sector ceasing business with these individuals or banks ceasing business, did you also consider whether an enforcement action had taken place beforehand to sort of improve that deterrence factor, or whether or not that was just sort of just on the basis of the designation itself? Yeah.
Yes, I don't think we've seen any enforcement action in relation to those individuals. I don't think there have been any attempts to deal with the property of those individuals that resulted in an enforcement action. In relation to at least one of the individuals, off the top of my head, there was an attempt to challenge the sanctions in a US court by him. So that individual was simply trying to have the sanctions lifted, but there's no evidence that that person either attempted to evade sanctions or that other US persons had sought to engage with him. So I don't think we've seen any enforcement action there, and that might simply be a reflection of the sample of the individuals that we looked at, they were all, well, a lot of them were pretty high profile. So I think they were rather, not maybe toxic is not quite the right word, but a lot of the people who might have been tempted to deal with sanctioned individuals, in principle, I think even they would be reluctant to engage with that particular lot by virtue of their notoriety. So we haven't seen any enforcement action, no.
Can we have another online question?
Yeah, so this is more of a comment. It's from Robert Mwanyamba. Sanctions regimes are, as pointed out, not a panacea to fight against corruption. But from an impact perspective, it would be interesting to look at the domino effect of sanctions. Say, for instance, domestic action beyond investigations and prosecutions and into legislative and policy reforms, establishment of enforcement agencies and institutions, and increased capacity. That, I believe, would demonstrate broader impact.
Lots of nodding.
Yeah. Great point. There was one other question. I do appreciate the brevity of it. Samuel Harrison Cujo asked, do sanctions work? Does really lead into the evidence point of sanctions working with respect to fighting corruption?
Short question, probably a very long answer. Anton, would you like to go first?
Well, look, I think that the best indicator of sanctions working in the broadest sense possible would be that behavior change by the broader regime or network. And that also goes to the comment about the domino effect. I think that would be a good indication of that systemic change. We haven't seen that in relation to that specific sample. But I think that if one could see that happen as a result of a sanctions designation, that would be, when you strike gold, and then you just try to make sure that you impose sanctions in a way that achieves that. I mean, that would really be the, I think, ideal end game. And this is just not something that we came across in relation to those 18 case studies.
Yeah, please.
I think this is where I started to hear my intervention. To ask questions, do sanctions work? I think we shouldn't second guess. We need the data. And I think this report is testament to that we need to look much deeper and not assume or prejudge whether they work or not. It's very easy to say they don't work. I think it's very easy narrative to sell. So that's my answer would be, let's take time and let's look at deeper levels. What does it mean that sanctions work? Very much agree with Emily that we shouldn't question just one instrument, which is a tool of it in a toolbox, right? So we should look at it in a multiplicity of the different instruments. So that would be my answer to that.
No, I think in a similar way, sort of my response, and this is not the first time this question comes up. My answer is, or my response is always like, define what you mean by work, because does it freeze assets and prevent people from traveling who are involved in corruption around the world? Yes. Would there be, are there other mechanisms to do that? Generally speaking, no. Generally speaking, those assets wouldn't be frozen in another way. You're looking at criminal prosecution domestically or, a sort of cross-border case, but they're very rare. So, in that terms, yes, they do work because they do put a plug or they do have an impact on corrupt actors around the world. Whether it prevents corruption, does it prevent corruption, generally speaking? No, because that's a much wider issue. So I think the answer is you have to define what you mean by work. And I think in most cases, individual cases have an impact on corruption. But the bigger question is really sort of how do we tackle corruption rather than whether sanctions work, would be my sort of pushback on that question. But thank you for the question anyway. That's it.
Yeah, we are out. Well, we're over time, but that was testament to the great conversation and contributions from everyone. So thank you from me to our panel, to all our contributions, and I'll hand over to Lucy just for some final remarks.
Really just to say thank you all for coming, for joining the discussion. It's been, yes, it's over time just because there's so much to say. So those of you in the room, we can kind of continue that over some refreshments afterwards. Thank you very much to our panelists, to Anton, to Emily, Tika, Oliver, to Liz for moderating. Thank you to HSF for hosting us, seamless technology. Thank you also to a couple of people online, Eva and Megan, our co-authors of the report who couldn't join in person, but I know are online, to Steph for organising everything, to Maria Christina for organising everything as well, and also huge thanks to OSF for the ongoing support, guidance and collaboration. Thank you, everyone. Goodbye.